This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about whether or not a COVID-19 lawsuit is frivolous and why the Ninth Circuit Court of Appeal is exhausted by COVID insurance claim suits. Khatchik Hairabedian, doing business as Kris Mobil, appealed from the district court's order granting Defendant Security National Insurance Company's motion to dismiss the action for insurance coverage in a case called Khatchik Hairabedian versus Security National Insurance Company, a July 21, 2023 decision of the U.S. Court of Appeals for the Ninth Circuit. Khatchik sought coverage from its insurer Security for COVID-19 related economic losses. However, the policy he had contained a virus exclusion that provides, quote, Security will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease, close quote. The virus exclusion also, quote, applies to all coverage under all forms and endorsements, close quote, in the policy, including, quote, forms or endorsements that cover business income, extra expense, or action of civil authority, close quote. Khatchik argued that the virus exclusion does not apply because government orders, not COVID-19, caused the losses. Here, COVID-19 was and is the efficient proximate cause of Khatchik's alleged losses. Khatchik also contended that the virus exclusion does not apply to pandemics because Security chose not to use a publicly available pandemic exclusion in its policy. The Ninth Circuit disagreed, arguing that the virus exclusion does not apply to bar coverage for losses stemming from the COVID-19 pandemic, defies the plain and unambiguous text of the policy, and is akin to arguing that a coverage exclusion for damage caused by fire does not apply to damage caused by a very large fire. In my opinion, the Ninth Circuit is getting annoyed, and it is time that courts stop dealing with lawsuits seeking insurance coverage resulting from COVID-19. They continue to fill the trial and appellate courts, and they continue to lose. They are causing unnecessary expense to the plaintiffs, the insurers, and the courts. Considering the volume of precedent, it is beginning to be considered a frivolous lawsuit that would subject the parties and their lawyers to sanctions, and this would apply to all policies with such an exclusion or with a requirement that there be direct physical loss to property. Of course, there are some policies that do cover COVID-19 lawsuits, and they simply do not go to litigation about COVID-19. They are covered and the losses are paid. It is time, however, with the excluded ones to stop dealing with these people and to start issuing sanctions for filing a frivolous lawsuit in the light of unbelievably strong precedent. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice of every issue, usually 5 a week, plus access to all 4,550 or more blog postings. You can also subscribe to these videos on rumble.com or on youtube.com, also free. And if you wish detail or a great bit of information about insurance, insurance law, insurance fraud, and insurance claims, please consider, for a very small fee, subscribing to my locals community or to my Substack publications. Thank you for your attention.